Okay, great. Well,
Okay.
everyone, I apologize for the technical difficulties. My name's Dan Bennett. I'm an attorney at Alden Law, or transportation law firm in Columbus, Ohio. And thanks for everyone for calling in. I know everyone has busy days, and appreciate you guys listening in. I want to thank Sam and the OTA for putting this on. Just some bit of housekeeping. So I do think, assuming the technology is allowing it to happen, you guys should have a box on your screens that enables you to ask questions. And so as we go along, if something pops in your head, go ahead and type it out. If I catch it and it's on topic and I can answer it kind of in real time, I'll do so. Otherwise, we'll try and hit questions at the end. So with that said, let's get started. So this is it's a big topic, and Sam circulated the roster of attendees, and we've got a diverse group with us here. We've got carriers ranging from, gigantic, worldwide carriers to, we've got some mom and pops on the line. We've got owners, we've got operations folks, we got HR, we got some lawyers, we got some OTA board members. So long story short, it was a kind of tough to figure out, well, how am I going to target this, given that, some of the folks on the line, like the lawyers, are going to, if anything, be just as well qualified, if not better, than me to talk about this topic. How am I going to set it up so that everyone is getting something out of value out of this presentation? So I'm going to hit three sections. So the first section is going to be the basics. I've called it Misclassification Liability 101. So for those who are coming in, and this is a newer issue, I'm going to talk about, what is the issue, what's at stake, what are the basic tests out there that resolve the issue as to whether a driver is an owner-operator or an employee, and then I'll go through a couple examples. I'm going to do a middle section where I'm going to talk about some of the stuff that we've been seeing in the press, recent decisions, recent legislative activities, and that'll be more geared towards folks who are really keyed in on this issue anyway, and they just want to know, well, what is the, what's new, what's the kind of cutting edge decisions in this area. And then third, I'll talk about strategies to minimize the risk that your company is subject to a claim for misclassification. And I'll walk through both the legal and then some practical strategies to avoid liability. So let's start at the very beginning. What is the issue here? What is an employee? Well, an employee is a worker who receives regular paychecks. They're paid for all the time on the clock. There's a whole lot of statutory benefits and protections, and taxes are withheld from every paycheck, and then the employer passes those on to the taxing authorities. Conversely, an independent contractor, they get paid a gross amount of money. Theoretically, they're going to be paying taxes on that later on when they do their quarterly filings. That doesn't always happen. But they're also able to deduct business expenses. In essence, they're running, almost like a separate business. And, why do we care about the distinction? And like a lot of things, it boils down to money. So there are all sorts of different areas where the classification of your worker as an employee or independent contractor matters from a compensation and or benefits perspective. So taxes, for instance. So even though theoretically the independent contractor should be paying taxes on the amounts that he or she receives, in practice, the IRS has a strong preference for the W-2 model because they just have a lot more certainty that they're going to get their taxing revenue. And so, the analysis that the taxing authorities do, as a comparison of receipts based on an employee model versus an independent contractor model, the taxing authorities get paid more when employees, or I should say workers, are treated as a W-2 employee. Employment laws. So there are all sorts of regulations, as probably most of you know, that relate to the employment relationship, and where a series of workers thinks that they have been paid less than a regulation otherwise suggested they should be paid. It doesn't take much for them to connect with the plaintiff's attorney or the state's relevant enforcement agency to, advance an argument that they were misclassified and therefore they're entitled to compensation, reimbursement for employment expenses, et cetera. So same thing with workers' comp and unemployment. I mean, the drivers generally don't really care about workers' comp until something actually happens and then they're injured. And then if they're an owner operator and they didn't take the steps to actually secure their own workers' comp coverage, and it turns out that they're not covered and they get into a situation where they're hurt and the medical bills are piling up and they don't have the money to pay those, they're likely to argue that they were misclassified. So at the end of the day, like so many things, it boils down to money. So how do you know if your driver is an employee or an independent contractor? Well, there are lots of different tests out there, and I'm going to walk through kind of 3 common ones on this slide, and a couple of the cases I'll talk about in a little bit have different tests. And you'll see that this is a pretty muddy area. There really is no bright line test, no way where, if I was advising a client, I could say with 100% certainty that, the owner-operator model that they're using is bulletproof. So these tests, I'll start with the right to control test. Ohio courts, state courts, I should say, use this test. And the theory is basically how much control does the company have over the manner and means of accomplishing the result that the worker is trying to accomplish. And so they focus at, really on, does the employer have the right to control, how the employee is doing what he's doing when he does it. So think about things like, training or established methods that all get at control. Second test, economic realities test. Department of Labor uses that. Ohio's federal courts are going to use that test. That really looks at, well, how dependent is that worker on the company for compensation. In other words, the more that a worker controls his own destiny, separate and apart from his relationship with the company that he's currently doing work for, the more likely that that worker is going to be regarded as an independent contractor rather than an employee. And all of these are really, fact-specific analyses. I'm kind of glossing over a lot of the details in part because I just want to keep this, within the allotted time. Like the IRS 20-factor test. I'll just run through about half of them so you get a sense of, even in the other 2 tests I referenced, a court will often examine from an inquiry perspective and rely upon, when they're applying the law, various factors in determining whether the employee should be, I should say the worker, should be regarded as an employee or independent contractor. So here's a quick, hitting about half of them. So IRS factor number 1, is the worker required to comply with employer's instructions about when, where, and how to work? 2, is training required? 3, are the worker's services integrated with activities of the company? 4, is the worker required to perform the work personally? 5, does the worker have the ability to hire, supervise, and pay assistance for the employer? Does the worker have a continuing relationship with the employer? Is the worker required to follow set hours of work? Does the worker work full-time for the employer? You can see all these different factors. If you're going to check the box yes or no, the more of these that you're checking yes, the more it's going to look like, at least in the IRS's eyes, and again, depending on the court, the more it's going to look like, your driver is an employee rather than an independent contractor. So let me walk through two cases here to try and illustrate why this is a big deal in the trucking industry, as well as other industries. We're not the only ones who are confronting this issue, but it's definitely pertinent given that the owner-operator model has been around for as long as it has. So this is a really prominent case, Alexander versus FedEx Ground. So FedEx uses owner-operators for basically final mile operations, and in the mid-2000s, there were a variety of lawsuits filed all over the place, alleging that FedEx had violated employment laws. In particular, that the overtime regulations and regulations with respect to paying expenses incurred in connection with fulfilling their employment were not reimbursed. So again, they're looking for money through a fairly complicated procedural process. All of these cases were eventually consolidated into the federal court in California, which is the forum that is most favorable to drivers looking to argue that they were misclassified and that they were in fact employees. So FedEx won the case. It went up to the appellate court within this federal district. And the facts, I think, are pretty helpful from the perspective of we've got the agreement between FedEx and the drivers had a reasonably decent amount of language labeling themselves independent contractor and company rather than employer and employee. The problem was when the court dug into the testimony and the evidence, it indicated, I think, persuasively that FedEx was really controlling these guys. And I will note, for anyone who ever digs into a court case and actually reads the decision, that judges are going to tend to emphasize in their decision the facts that support their decision. So it's certainly possible that the opinion on its face isn't really telling the whole story here, but certainly the background that the court provided in terms of how FedEx basically controlled the drivers seemed to indicate that, yeah, under most of the tests that are out there, if not all of them, these drivers were employees and they were misclassified. I list a bunch of things here on the slide that you can see. I think it was a fairly extensive amount of control that they were exerting. And in California, they did in fact apply the right to control test, and they found that the drivers were employees. And there's some language in the opinion that's kind of colorful, that it kind of gets at the old saying that's slightly different from this one. If it walks like a duck and quacks like a duck, well, it's a duck, and that's essentially what the court was saying here. So the fallout, FedEx put $228 million into a fund to settle the case. So, there's big money at stake here. Another example to just describe kind of the situation and the background here. So a little bit closer to home, that state up north, a 2015 case. It was in the workers' comp world. Michigan's workers' comp is different than Ohio in that private insurers actually underwrite the policies. There's not a state-sponsored fund like here in Ohio. And so Liberty Mutual was the insurer, and they conducted an audit, basically trying to make sure that the risk that they were underwriting was commensurate with the actual risk that was out there. And they believed that a certain number of the drivers that the trucking company had characterized as independent contractors who are not eligible for workers' comp, through the employer, that they were misclassified and they were actually employees. And As a result, Liberty Mutual essentially said, well, you owe us more money. You owe us $100 grand and change. So Max Trucking, the carrier, they refused to pay. They said, no, these guys are owner operators. We don't owe you the money. And the facts in this, unlike that FedEx case, I think are much closer to what we typically see in a owner-operator relationship. So to kind of, again, go back to that, courts will use language to kind of preview their result. This particular carrier acquired itself title to the vehicles and then turned around and leased those vehicles directly to the drivers, and the court literally called it a financing scheme. That seems a little bit aggressive in terms of characterizing that relationship, but I do see this all the time. Clients regularly will do this rather than setting up a separate leasing company, which we typically recommend. But other than that, the rest of the relationship, both on paper in terms of what the independent contractor agreement said and the company's practice, was fairly consistent with what we see and even consistent with agreements that we would draft. I had a lot of the provisions that you'd want to see. Now, the facts were that the drivers didn't always take advantage of that freedom that was provided to them under the agreement. That, I think, again, is not necessarily unusual, that the driver, for instance, in this case, didn't haul for another carrier, or that the drivers usually were behind the wheel of their own leased vehicle rather than hiring someone else. But, this was not an egregious case of the employer exerting control. What the problem with this case was the test. So Michigan's workers' comp statute had a three-factor test that was much broader than the ones I talked about earlier. So I'm going to key in on the second prong of the test under Michigan's workers' comp statute. A person is an employee basically unless they hold themselves out, as rendering services to the public. And we all know owner-operators, by law, by DOT regulation, they need to have the name of the carrier and the DOT number and the NC number on the door. So they're not advertising their own services, and in fact, they can't. So you've got a little bit of a mismatch between the industry practice, the industry laws, and Michigan workers' comp statute. So, the punchline here is that the legal test in your jurisdiction can have a very meaningful result if you're confronted with a claim. I think had this case been analyzed under the IRS 20-factor test, I think we would have gotten a different result. So that's kind of the high level. This is it's a big deal in that we see this still happening. There is a active plaintiffs bar out there who almost exclusively are targeting prospective clients so that they can turn around and sue your company, and they know that just the expense alone of defending a class action lawsuit, it can get really, really expensive. Setting aside what us lawyers might think the results would be and the exposure is from the perspective of the merits of the case, typically you have to factor in, and certainly businesses care about how much they're spending to defend those claims. So it's a big deal. If other than a catastrophic accident in excess of policy limits, if I was an owner of a smaller carrier, this would be the other item that would keep me up at night, just because it only takes one or two drivers to be disenfranchised and go out and look for plaintiff's counsel to tee up a class action lawsuit. So shifting gears to, again, the more kind of the topics that are current, some of the stuff that I'm seeing in the case law, an update, if you will, on the existing principles that I just talked about. So I'm going to run through a couple recent cases and other legal developments. So F4A, so as background for folks who aren't familiar with this, F4A is a federal statute that provides that any state law that relates to a price, route, or service of any motor carrier is preempted. In other words, the state law doesn't govern the relationship. They want federal law to govern it. And so when a party is ever asserting claims under state employment laws, there's an argument out there that they can't bring those claims because the state laws are not applicable to motor carrier operations. So historically, I have not seen much success with motor carriers invoking the preemption argument, even though cases will characterize that preemption as being broad and indicating that even state laws that indirectly affect price, route, and service, courts still, what I've seen, tend to find a way of getting around saying that their own laws are on its face preempted. So this case is different in that ultimately FedEx was able to prevail, arguing that similar to that Michigan workers' comp statute, a very broad Massachusetts statute related to employment, that was effectively preempted. It was too broad, and that second prong, and I've got it up there, is you're an employee unless the service is performed by the person outside the usual course of the business of the employer, and that's I struggle to see how any owner-operator agreement or arrangement could survive scrutiny if that was the test. And in fact, they basically said, look, this is so broad, FedEx said this, that it's so broad that it necessarily has to relate to our price and the service. And they were able to persuade the court that that was right. So it does provide some ammunition for practitioners who are trying to make an F4A argument. There are two caveats. The second one is that there's a lot of authority that goes the other way. And the other caveat is there's some language in this, in the opinion, where the court was basically saying, we're ruling this way because the statute is as broad as it is, and for other state laws that conform to norms, they likely would come up with a different result. So another new topic, this one's very timely in the sense that it just came out in May. There was the issue of whether the Federal Arbitration Act, an exemption within it, applies to contracts of transportation workers that establish or purport to establish an independent contract relationship. So again, some background for folks who don't necessarily know the lingo here. So the Federal Arbitration Act is a statutory scheme passed by Congress way back in the 1920s, basically telling the courts, hey, we want to favor arbitration. So when there's an arbitration provision in a transaction involving commerce, courts, we want you to enforce it. And in the motor carrier world, arbitration is kind of a hot topic because the carrier is probably always going to prefer to be in arbitration. And there's a couple reasons for that. One is arbitration, you can, within the contract, basically craft the rules. So if you don't want to have a jury, and no one does, then you can say, this is going to be the person who's going to rule on this case. And you can pick one individual who has experience in the industry, or a panel of folks who have experience on the industry to to be basically the judge and the jury, which I think from a motor carrier's perspective is always going to be helpful, because you get someone who understands the industry, who understands the owner-operator model, and can have that background inform their decision. You also, it's generally believed that your verdict, your actual exposure, even if there is a finding of liability, is going to be lower when an arbitrator is making the ruling, rather than a jury where you could have a median education age of halfway through high school, and you just don't know. There's just very little predictability in terms of your jury pool on what kind of verdict you might get. Another reason for preferring arbitration is generally they're conducted in private. So the testimony, the pleadings, those are not readily accessible by the public. So for companies that have some brand awareness, or larger companies who don't want the issue of a lawsuit getting out to other drivers, smaller companies, I think that's inevitable. Having basically the provision being held in private has a benefit. So for the most part, courts have effectively said that the Federal Arbitration Act applies to owner-operator agreements. And unfortunately, the First Circuit very recently went the other way, and they indicated that an exemption within the Federal Arbitration Act includes contracts that purport to establish an independent contractor relationship. And the way they got there is, I guess I'll describe it as interesting. So the exemption that they're talking about here relates to, quote, contracts of employment. So, you take your first rule of statutory interpretation. You're supposed to give the statute its ordinary meaning. Well, I think contract of employment has a fairly clear-cut ordinary meaning, and it necessarily relates to the existence of an employer-employee relationship. But the First Circuit doesn't agree with me. They said ordinary meaning of the phrase contracts of employment simply means an agreement to do work. So really broad interpretation of the exemption in the FAA. It's still the minority position. Also, a lot of states are going to have their own arbitration framework that does not have the exemption. And so if you're looking to enforce an arbitration provision within your owner-operator agreement, you just got to be sure that you're looking at all the avenues that you can do so. And knock on wood, you still have some luck in getting that enforced. Another very recent case. So this is a non-trucking case, but it still caught my eye because there is, I think, a relationship or an impact that this case could have on the trucking industry. So, a fancy, nice bell and whistle to have in your owner-operator agreement is not just an arbitration provision, but within that, an agreement by the driver that any arbitration provision is going to be conducted in an individual capacity rather than a class action. It's called a class action waiver. And this is, if it's enforced, is a big deal for all the reasons I talked about earlier in terms of costs of defending a class action. A lawsuit by one driver is both dramatically cheaper to defend, and then your exposure on the merits is going to be, proportionately that much smaller. So you've got basically a much more advantageous situation from a motor carrier's perspective. So in this case, Sixth Circuit, which is the circuit, the federal circuit that Ohio cases appeal to, so it's our home court, they found that a class action waiver in a non-trucking context with employees was unenforceable. There are a couple other circuits that are in agreement with the Sixth Circuit. The Fifth Circuit goes the opposite way, but I can see some not that creative lawyering where they'll start to bring in the rationale of this case when addressing that same provision within an owner-operator agreement. So we'll see, we'll see in the years to come how this develops. So another interesting case that caught my eye, very recent. In this case, and you may recognize the name, Travis Kalanick, if I'm saying that right, the former CEO of Uber and its founder. The drivers out in California filed suit against just Travis Kalanick. They did not sue Uber, and they were alleging that they were misclassified. So why did they do that? Well, one, in California, the statute imposing liability for misclassification has a provision that if that misclassification is, quote, willful, which basically means, was it done on purpose? Was it done with intent? That the officers of the company can be personally liable. So the strategy here was, because there was an arbitration provision in the agreement between the drivers and Uber, they basically got around that provision by just going after the owner. Now, this is a brand new case, so I have no idea, how this is going to result on the merits. I will say, even under California's very favorable statute, I'm struggling to see how Uber drivers could be regarded as employees just based on what I know about their business model. I mean, I think a driver for Uber has maximum flexibility in terms of when they work, how they do it, all that stuff. So it'll be interesting to see how that comes out from a on the merits perspective. Two other, I guess, to summarize, so a bunch of cases. I think on a whole, I am seeing cases go the direction of the plaintiffs. Most of those cases that I just hit, the court was, finding a way to provide those workers with the rights and compensation, of an employee, or make it more difficult by not enforcing an arbitration provision, or should say make it less difficult by not enforcing an arbitration provision. Conversely, from a government perspective, at least on the federal level, we may be going in the opposite direction. So on June 7th of this year, the Trump Department of Labor withdrew certain guidance on independent contractor misclassification standards that was issued under the Obama Department of Labor back in 2015 and 2016. So, for background, the Obama DOL guidance, from my perspective, wasn't anything necessarily new. What they did make clear was that as an agency, they regarded most of the relationships where workers were being 1099 as improper, and they were in fact W-2, and they also signaled that this was something that they were going to be looking at closely from an enforcement perspective. So, what does that mean when Trump withdraws that? I'm not sure, because the reality is there are lots of regulatory bodies and private cause of action where, if I was advising a motor carrier pre that 2015 guidance, and now I'm probably going to provide the same advice, which is, this is an issue. You need to, look at what the law is in your particular state. So I didn't view it as a game changer, and so I don't view it as one now, but it does signal that I think the Trump DOL is going to look at this as less important than the Obama DOL was doing. So one more legislative effort here. There was a bill that was introduced very recently, sponsored by a House representative out of Minnesota, which would dramatically simplify the IRS standard. In this proposed legislation, rather than having a 20-factor test, they would have a 3-factor test, and it looked fairly bright line to me. It was really focused on basically the expenses and the risk that a worker takes on. In other words, that a worker, the amount of money that he takes home net is subject to, market forces, and, in our case, the price of gas and all that stuff. And so I think if that's adopted, that's passed, and let's be honest, if it's just sitting in a committee in the House, which it is right now, we're a long, long ways away from something like this being passed, even with Republican control of both House, Senate, and the executive branch. But something to keep an eye on. I think that, again, from an IRS perspective, it would dramatically simplify the analysis and would give companies, including motor carriers, comfort that at least from an IRS perspective, their owner-operator model is not going to be disregarded. So last section, legal strategies to mitigate risk. So what do I want you, business owner, to implement to try and protect your business? So the first thing is your independent contractor agreement. It does matter. It is very important. Even though there have been circumstances, even that I've gone over here, like the FedEx case, where a court disregarded some of the express terms, you still need to have those. You definitely need to essentially, follow through with those terms of the agreement. But as a threshold matter, if you're not checking off the boxes on providing your owner-operator with the freedoms that they would need to be fairly characterized as an independent contractor in the very agreement that governs the relationship, you're going to have problems trying to persuade a government agency or a judge and jury that your driver should be treated as an independent contractor. So I've listed a handful of terms that I want to see in an independent contractor agreement. And it's a common theme. You got to give them some freedom. They have to be able to run things like their own business, like their own boss, within reason. I mean, clearly, they've got to comply with safety requirements, and it's appropriate to include those within the agreement. And I would have no problem standing up in front of any judge anywhere and saying that, merely requiring your drivers to comply with FMCSA regulations does not, create some situation where you have control over them. You're just saying, hey, you guys need to follow the law. So other than that, you got to give them the freedom to take loads when they want, drive for other carriers if they want, et cetera, et cetera. So other legal strategies. So obviously, Ohio Trucking Association, let's talk about Ohio for a second. Know your state's law. I'm going to guess that most of the attendees today are calling in from Ohio locations. The owner-operator model is alive and well in Ohio. We are, by no means have we reached California status in terms of courts really hammering companies for misclassifying their workers. So my office has had a couple cases recently where we've gotten, in my view, the appropriate result, where court was able to basically honor the provisions of the independent contractor agreement. The most recent one, we represented a courier the driver was injured. He signed a very solid independent contractor agreement. He went ahead and filed a workers' comp claim anyway, and we defended it on the basis that he was an independent contractor, and we were able to prevail. So, couriers, I know because I've seen it. Some couriers in Ohio have gotten hit with class action lawsuits. From my perspective, couriers should be a little bit more insulated from a claim of misclassification in Ohio, because most of the time the courier is using their own vehicle. There is no more complicated, quote, financing scheme, as that one case talked about. They're bringing their own vehicle, or in some cases bike. So they're bringing their own tools. There's usually no dispute with that. So I think couriers are typically going to have that additional factual background or support for an argument that the drivers are properly characterized as an independent contractor. So same thing with federal courts. I've talked already about federal courts having different approaches, so that matters. Know how courts are looking at it within your federal circuit. What you do in terms of how you treat and deal with your owner-operators should match what's in the agreement. So if you're going to give them those freedoms in the agreement, you need to follow through and actually allow them to utilize those freedoms from an operational perspective. So separate leasing company. So this is probably a blanket recommendation that we make. If a carrier is going to arrange for a driver to lease their own power unit, they should form a separate leasing company. They should not, the carrier itself should not be the equipment lessor and then have the driver turn around and lease onto the motor carrier. Again, we're trying to create I don't want to say the appearance that a driver is bringing his own power unit to the relationship, because that leasing agreement, which you ultimately are going to need to have after you form the leasing company, should be similar to an arm's length lease that you would get from a Penske or any of those big boys. It's a you pay us this monthly fee, take care of the vehicle. At the end of the term, you give it back or you buy it if there's a purchase option, but it should look like a bona fide lease. And in fact, if that driver wants to take that power unit and lease on to another carrier, you need to let him do that, as somewhat distasteful as that can be. And then you then have the separate owner-operator agreement between the driver and your motor carrier company. And that way, you've just created another barrier to allowing a plaintiff's attorney to argue, no, this is really a employer-employee relationship. Last one, comply with other applicable laws. This is, I think, more kind of common sense, but the less that you have government agencies in your business, the less chance there is that a driver is going to consult with an attorney, the better off you are. So, something like the leasing regulations, your owner-operator agreement on its own, it should comply with the leasing regulations. But additionally, you don't want to give that driver an excuse to go consult with an attorney who, can discover that, okay, well, it looks like we don't have much in the way of damages for a violation of a truth in leasing reg, but I can argue that you were mischaracterized and I can get your claim, multiples of what we'd have under a truth in leasing claim. So, keep your business on the up and up from an overall compliance perspective. Last slide, practical strategies to mitigate risk. So the magic bullet, convert your drivers to W-2. So I know that that is, in a lot of situations, not a realistic ask, but I am throwing it out there as that is a solution. And if I was advising, for instance, a motor carrier in California, I would tell them that the risk of having an owner-operator model outweighs the benefits, and that they should bite the bullet and convert their drivers to W-2s. I also want to say that we have seen at least one very large retailer insist on having carriers employ their drivers on a W-2 basis. That seems like, our impression was that was a bit of an overreach. I don't know why this particular retailer was insisting on that, because I'm having trouble connecting the dots as to how this retailer could get pulled in to this misclassification issue of the carrier. But we've seen that. So, if your customers are insisting on this, you may be losing business by having owner operators. That's not a widespread, but some of the bigger boys, we're seeing that. And then the last three is just common sense. Again, it only takes one driver to pick up the phone and call that class action law firm. So I know, right, driver shortage, but hire the best that you can. Treat your drivers fairly. When you get complaints from your drivers, particularly as it relates to compensation, take it seriously. I would definitely pick up the phone and talk with your legal counsel, but take it seriously. That doesn't necessarily mean that you need to fork over money if they're saying that they, weren't paid for something that they should have been. But I think drivers, they just want to have a little bit of respect. And so if you take their complaints seriously, you try and walk them through respectfully, why you've done what you need to do under your contract, and that everything is square. That ounce of prevention, as they say, is a whole lot better than a pound of cure. So with that said, thank you for calling in. Very much appreciate the time. Thanks again to Sam and the folks at the OTA for setting this up. I would very much appreciate any feedback, both on the presentation, that kind of dilemma I talked about earlier about trying to make this helpful for a diverse cross-section of folks within the industry. Was I on target there? Any additional topics where, you, the industry, would like to hear? I'd be curious about that as well. And then there's my contact info. If anyone has any questions or comments, please feel free to get a hold of me. So with that said, I'm done. Sam, I don't know if you got any thoughts or comments?
There are several questions, actually.
Oh, okay. I'm not seeing them in my chat box, so if the technical difficulties are persisting, are you able to read them to me, and we can see if we can hit them on the fly?
Yep. Are you ready? Okay.
Yeah, go ahead.
So what about drivers who do not own their own vehicles? There are many motor carriers that use drivers as independent contractors instead of hiring them. How is that relationship usually misclassified? Any cases that support this? Yeah,
so that's, I think we hit that a little bit on the recommendation to have a leasing company in place if effectively, your company is trying to facilitate a driver having his own truck. So, are there specific cases? The test is, there's so many factors in place with most of the tests out there that I don't think having a motor carrier itself lease a vehicle to a driver is going to be dispositive, but it's really not that difficult or expensive to get that leasing company set up and create that layer of separation.
Okay, and then the next question is, how is Uber able to separate themselves from this on such a large scale?
Well, I think I'd have to know separate from Separate from what? I mean, they're getting sued. I should say their CEO is getting sued. I don't know if there's litigation elsewhere, but I'm guessing there is. So I'll probably Google it when we get off. So I don't necessarily know that Uber is separating themselves from this.
Brandon. Yeah, we can get back to Brandon on that question.
All right.
And then Phil Davinsky, he wants to know, what is the 3-part test?
The IRS 3-part test is what I'm guessing.
Yes.
Well, here since he wants to know, let me pull it here. Okay, so now again, this isn't in effect. So, this is at this point, just a proposal. But let me pull it up here. Okay, so let me try and kind of paraphrase this on the fly. So you're an independent contractor if you, 1, incur significant unreimbursed expenses as it relates to total expense, or risks income fluctuations because remuneration with respect to such services is not related to the expenses incurred. So again, that's that kind of distinction between is the driver taking on some risk that he can have some upside and some downside depending on market conditions. Okay, part 2, agrees to perform the service for a particular amount of time to achieve a specific result or to complete a specific task. I think the owner-operator model checks that box pretty clearly, because the specific task is pick up the load at point A and take it to point B. And then last, 3rd factor, at least one of the following is present, has a significant unreimbursed expense as it relates to total expense in assets or training, or is not required to perform services exclusively for the service recipient. So again, if we've got that provision in our owner-operator agreement, we should be home free, and then has not performed services for the service recipient as an employee during the 1-year period ending with the date of the commencement of services under the contract described in subsection D. So I guess the first little I and 3 little I, I'd have to look at more, but clearly that, under the proposed rule where there's not an exclusive relationship, we'd meet that. So I think if that 3-part test is implemented from an IRS perspective, the owner-operator model is going to be good to go.
Okay, and then the last one, which is kind of lengthy. So tell me if you would rather just email the answer later, but I'll read it to you. It says,
okay.
We lease our older trucks to independent contractors on a 2-year note at market value. We have a lease purchase contract and a contract lease on contract. Since we manage our own lease program, how can we allow contractors that are buying a truck from us also pull freight for others if our DOT number is on the side of the truck?
Well, yeah, you got to take the DOT number off, and I know that's a pain. What I typically see is kind of a magnetic covering that goes over the existing carrier, and allows the new carrier, if you will, to put that on a temporary basis their information on the door. But I think let's take an easier example. Your lessee just terminates the owner-operator agreement, which, to go back to one of my earlier slides, a provision you should have in your owner-operator agreement is mutual termination rights. So you should allow an owner-operator to walk away if they want to. I mean, that freedom is pretty customary for independent contractors. So if they want to terminate their owner-operator relationship, then what would happen is that there should be a provision within the owner-operator agreement on what they have to do at termination, and it should include you got to take our information off of the door, but then he would just take his power unit onto the next carrier. So again, I know there's some reluctance to let a driver do that, but if we're trying to minimize exposure to independent contractor misclassification liability, you gotta include a provision like that. Otherwise, you're basically kind of chaining that driver and that vehicle to your motor carrier, and courts are going to see that as an indication of control, and so it's going to be a factor weighing towards finding that the driver was misclassified. So yeah, that was somewhat of a specific question, and it does matter. Again, all those factors I went through, it does matter what the rest of the landscape looks like, but just in terms of that particular question, I guess hopefully I answered that.
Okay, and well, there's a part two. It says, how does that work if case law is saying we need to allow contractors to also pull other freight, and how can we have other drivers drive the truck that the contractor is leasing from us? All drivers must be DOT qualified and meet our insurance minimums. Do you need to use a third party to manage the lease?
Well, yeah. So I guess let me hit this part of the question. So it's entirely proper within the owner-operator agreement to allow the owner-operator to hire his own drivers, provided that that driver has a CDL. You can even put restrictions on, we want their MVR to look like this, and we don't want to see, we don't want to see any serious traffic violations within the past 3 years, or you can qualify the type of drivers that they can put in there, so you essentially retain, some control over, over your customer's freight, and make sure that it's going to get there safely. I don't think a court is going to would frown upon that, but again, it's just, if we're going to maximize or I should say, minimize our risk of being found liable for misclassifying our drivers as independent contractors, we want to give them that freedom. Because if you don't give them that freedom, if you say, you driver, you have to drive this truck and no one else can, that feels to me anyway a lot more like you're exerting control over them, as opposed to you, Mr. Owner-Operator, are an entrepreneur and you can staff your own business the way that you want, subject to some pretty normal safety considerations that we're laying out in the agreement. So again, hopefully that answers that question. Please, if anyone else wants to go over this in more detail, then I'm more than happy to chat. Please give me a call.
Yeah, very good. There were several more questions. I will email those to Dan, and hopefully he can reply back to them, all the other questions that we've missed. But it's now 10 after 3, so we will.
Okay.
If you're done, Dan, we'll go ahead and just end the webinar.
I am. Thanks again, everyone.
Thank you.